New Deep Dive.
Hey there, you're listening to The Deep Dive. So imagine this. You hit delete on a chat, maybe something sensitive. Phew, gone,
Yeah.
right? Well, what if it turns out it's not gone? It's still there, stored somewhere, indefinitely, and maybe even usable in court.
Sounds a bit dramatic, maybe, but yeah, that's kind of what we're talking about today.
Exactly. Today we're diving deep into this intensifying legal fight between OpenAI and the New York Times, and specifically a really key federal court order about GpT user logs.
Yeah, our mission here is to unpack what this ruling actually means for your privacy, for how companies handle data now, and just, the whole AI landscape.
Think of it as your shortcut to getting the crucial stuff, the nuances. We'll try to keep it interesting, maybe even a little bit fun, despite the heavy topic.
We've got our sources lined up, some good legal takes from places like TechRadar.com, Adweek, DebtEconomy.com, plus news bits, all coming out of the actual court case.
All right, let's get into it.
Okay, so setting the scene. The New York Times sued OpenAI, and Microsoft is in there too back in 2023. The main charge, copyright infringement. They're saying OpenAI hoovered up millions of Times articles without asking, without paying, to train its AI models.
And OpenAI's response has been pretty consistent, hasn't it? They're calling the lawsuit baseless.
Yep, completely baseless. They argue what they did falls under fair use.
Ah, fair use. That always seems like such a gray area, especially with AI.
Yeah.
How's the court looking at that defense? Is it holding up?
Well, that's the million-dollar question, isn't it? Fair use is their main defense. It's this legal idea that you can use copyrighted stuff in limited ways without permission.
Like for commentary or research or transformative use?
Exactly. Transformative use is key. Does training an AI transform the original articles enough?
Yep.
Or is it just copying? That's the huge battleground. But at this stage of the lawsuit, the judge wasn't convinced enough by the fair use argument to block this specific order we're talking about.
Okay, so the court intervened. You mentioned U.S. District Judge Sidney Stein.
Right. Judge Stein rejected OpenAI's arguments against something called a preservation order.
Preservation order. Let's just quickly define that for everyone. What does that mean in practice?
Think of it like the court hitting pause. They're telling OpenAI, hold on, don't delete anything that might be relevant to this case. You need to save it.
Okay.
This specific order originally came from a magistrate judge, Ona Wang. They handle a lot of the pretrial stuff. And Judge Stein, the district judge, looked at OpenAI's objections and basically said, nope, the magistrate judge got it right. The order stands.
And that's being seen as a win for the Times.
Oh, yeah. A definite win for the Times and other media outlets watching this. It signals the court is taking the evidence side of things very seriously.
So this ruling, it kind of corners OpenAI a bit,
Yeah.
legally speaking.
Yeah.
What are their options now? Appeal.
They could try to appeal to the next level, the Second Circuit Court of Appeals, but it's a really tough path. They'd have to prove the lower court made a massive error, something called exceptional abuse of discretion.
Wow, sounds like a high bar.
It's incredibly high. It suggests the courts aren't messing around here. They're pushing back on that whole innovate first, ask questions later approach we sometimes see.
Right. So with options limited, let's look at what this order actually makes OpenAI do. What needs to be saved?
Okay, so the order specifically says OpenAI has to preserve all output log data that would otherwise be deleted, and crucially, indefinitely.
Indefinitely. Wow. And who does this apply to? Which users?
It covers a pretty wide range. Your ChatGPT free users plus Pro team accounts, and also people using the OpenAI API. That's the tool developers use to build ChatGPT into their own apps. The only exception there is if the developer has a specific zero data retention agreement.
Okay, so some API users might be excluded. But who else is definitely excluded?
Right, the big exclusions are ChatGPT Enterprise and ChatGPT Edu clients. If you're using those versions or if you have that zero data retention deal, this specific preservation mandate doesn't apply to your data.
Got it. So what kind of data are we talking about here? Stuff that normally gets deleted? Like what?
Well, think about temporary chats maybe, or messages you actively hit delete on in the interface.
Things you got were gone.
Exactly. And also API interactions. Normally, OpenAI purges a lot of that stuff after about 30 days. For privacy, for efficiency, now they have to keep it.
And why did the Times push for this? What was their argument for needing all this potentially deleted data saved?
Their argument was pretty direct. They alleged users were using ChatGPT to get around the Times AWOL, basically reading copyrighted articles for free via the AI.
Mm.
And then potentially these users were deleting those chats, what the Times called incriminating conversations, to hide what they did. They claimed OpenAI was actively destroying potential evidence on a large scale, significant ongoing destruction, and they wanted the court to stop it.
Okay. And OpenAI's response to holding on to all this data, they must have security protocols.
They say they do. They've stated the preserved data is securely stored and access is limited to a small, audited legal and security team within OpenAI, following rigorous legal protocols.
But still, holding data indefinitely when you normally delete it, that has to raise privacy concerns, right?
Huge concerns, and OpenAI themselves have voiced this.
Yeah, I saw their COO, Brad Lightcap, had some strong words. He called the order fundamentally inconsistent with the privacy commitments OpenAI made.
He did. He also said it abandons long-standing privacy norms and undermines privacy protections. Strong language.
It really highlights a potential clash, doesn't it? Especially with international laws. Like, what about GDPR in Europe?
Exactly. That's a massive headache for them. GDPR gives users the right to be forgotten, the right to have their data deleted upon request.
So how can OpenAI possibly comply with that if a U.S. court is ordering them to keep the data indefinitely for this case?
That's the conflict. They essentially can't fully honor those deletion requests for the data covered by this order. It puts them in a very tricky position between legal obligations in different jurisdictions.
You know, this whole thing really makes you reconsider what delete even means online. We click the button, we assume it's gone, like shredding paper.
Right. It's an illusion of control, almost.
But clearly, especially with AI systems that learn from interactions, it's way more complicated. What you think you deleted from the chat window is still sitting on a server somewhere.
Indefinitely, in this case. And accessible through legal processes, completely separate from what you wanted when you hit delete.
So even if I'm not involved in this NYT lawsuit at all, my supposedly deleted chats could theoretically end up as evidence somewhere else, like in a totally unrelated legal matter.
Potentially, yes. While this order is about the NYT case, the fact the data exists and is preserved means it could potentially be subject to subpoenas or warrants in other contexts down the line. Imagine a deleted prompt becoming evidence in a police investigation. It's a sobering thought.
Definitely sobering.
Um,
Okay, but let's bring it back to this case. How likely is it that the New York Times will actually get to read my specific chat logs? You said the order is about preservation, not automatic access, right?
Correct. That's a really crucial distinction. Preservation means don't delete it. Access means let us see it. They are not the same thing.
So the Times still has hurdles to jump.
Absolutely. They would need to go back to the court and make a strong argument that reviewing specific user logs, maybe yours, maybe mine, maybe a whole batch, is directly relevant and necessary for their copyright infringement claims.
And OpenAI would fight that.
They've said they will. OpenAI stated they will fight to protect user privacy at every step if the Times tries to get access to the actual content of user chats. Lightcap called the Times demand broad and unnecessary already.
Okay, so it's not a given they'll see the chats. What does it seem like the Times really wants with this preserved data then? Are they trying to catch individual users?
It doesn't really seem like it's about targeting individuals. Their main goal appears to be demonstrating two things. One, that ChatGPT does reproduce their copyrighted content, and two, the sheer scale of the alleged infringement.
So patterns,
Yeah.
showing it happened a lot, systemically.
Exactly. They're likely looking for broad evidence of copying and regurgitation, not necessarily singling out user X deleted this specific incriminating chat. Though, finding examples would certainly help their case.
So this whole situation really boils down to a fundamental tension, doesn't it?
It really does.
On one side, you have the legal system needing to preserve potential evidence, especially in a high-stakes copyright case like this.
Right. The need for transparency in legal discovery.
And on the other side, you have users' expectations, probably deeply ingrained expectations of privacy, and the idea that delete means delete, especially when interacting with something as personal as an AI chatbot.
Absolutely. It's a clash between established legal processes and rapidly evolving technology mixed with our fundamental ideas about digital privacy. What does deletion even mean anymore?
Which leads us to that final thought to leave you with. What does this ruling, this whole situation, really signal about the future of our digital privacy? About the permanence of our interactions with AI? Especially when that delete button might not be the escape hatch we always assumed it was. Something to think about.
Subscribe. New Deep Dive.